I reiterate, my position has been that there is no basis whatsoever for finding a prima facie case in respect of at least the three petitions that have come. And I'll go on to explain why. Can the president do something wrong in accordance with Article 146? Absolutely yes, because the whole purpose of Article 146 is guided by the Constitution generally and by the very provision of Article 146. Now we see the suspension, and need I say that Clause 10 of Article 146 permits by way of discretion, the exercise of discretion for the president to exercise this discretion to suspend the Chief Justice. And constitutionally, the exercise of discretion is again measured by the very Constitution in itself, Article 296, as elaborated in the plethora of cases by the Supreme Court. And so can the president fault? Yes, he can, in the exercise of discretion, where it is contrary to the very provisions of the Constitution. Now, coming to the very fact of this case, my position has been that there was no basis for the exercise of the discretion. And I'll say again, that first of all, if the only communication to the Chief Justice indicates without more that I have established a prima facie case in respect of the three petitions, the question is, will that alone suffice under the test under Article 296? I do not think so. Secondly, you look at the basis of these three petitions in substance to determine that even if on the face of it, a prima facie case may be made. Again, I do not think so. And I'll come back to it. Sam, if you look at the petition of, is this Savior Group or so, where the thrust of the petition is on two fronts. The first being that the Chief Justice recommended to the President, giving some reasons why the number of justices on the Supreme Court should be wide, it should be more. And then you say that that is a ground for petition for removal. Practice, as you are aware, is that the appointment of justices all throughout go through a process, including consultation with GBA, Judicial Council, etc. In any case, that letter that the Chief Justice wrote was a mere recommendation. We know the import of recommendation or even advice to the President. It is not binding on the President. Indeed, it shows that the President did not even proceed to act on that advice of the Chief Justice. And so for me, I find it questionable how such points stated by the Savior Group can present a ground for the establishment of a prima case. Second, and most importantly perhaps, is that the thrust of the petition of the group is that the Chief Justice, while sitting as a panel member of the Supreme Court, and you and I know that the Supreme Court's jurisdiction, unless it is a single justice of the Supreme Court acting on behalf of the Supreme Court, usually is not fewer than 5 justices of the Supreme Court. And so if the basis of the petition, which then ends up in the finding of a prima facie case, is that the CJ, who has 1 vote, just like all the other 4 judges on the panel, while sitting as a court, made certain decisions, gave certain orders that you are not satisfied with, the ground for it, I believe, is not Article 146. And I've always maintained that the Constitution and our laws in themselves present avenues for challenging decisions of the court. Now, I always tell people that I'll draw your attention to the very deep statement made by then Professor Justice Dapaah in the Ejechun case. Now, if you remember, there was a preliminary objection raised by one of the parties that this is a dispute in respect of the petition to remove the Chief Justice. So how can the Chief Justice himself, then Chief Justice Dapaah, empanel the member to determine this matter? And Justice Dapaah said something, and I admonish all Ghanaians to take a careful look and reflect on that statement. Indeed, he said, and I quote, that we, the rest of the judges at the Supreme Court, are not malleable clay in the hands of the Chief Justice. In other words, we have our independent thinking. We have our own, as it were, objectivity. So to suggest that we will be influenced by mere reason of the empaneling of the Chief Justice is unfortunate. And I do agree with him. And so for the petition to suggest that the Chief Justice, as part of the panel, as part of the court, made certain decisions, with all respect, is an insult to the rest of the justices that sat on the panel with him. In other words, they were so malleable that some of the decisions, which were unanimous, they were controlled by the Honorable Chief Justice. And I do not think that is a fair statement to make against the other justices of the Supreme Court. In any case, if you are dissatisfied with that decision where the Chief Justice presided, there are avenues for expressing that dissatisfaction. And secondly, when the Chief Justice sits as part of a panel, she could even be part of the minority. She could express a dissenting opinion. It is a decision. It is the order of the court. It is not a decision of the Tutokunu. It is, and again, let me go back. I don't like to even use personalities when it comes to issues of the judiciary. Especially, I mean, something is so coincidental that the first time I appeared on the show on Newsfile was in respect of matters on the judiciary, and have been consistent that in as much as we have the right to criticize, to be dissatisfied with decisions of the court, we have to be careful about not destroying the very tenets of our democracy. Because the judiciary continues, even on 6th January, when all the other arms of government are giving way after election to other parties or government to come into power. And so let's be very careful. And so to say that a decision of a court and not a decision of Tokonu is a basis for establishment of a prima facie case, I'm afraid I do not agree to that. You look at the other petition by Daniel Fori. Indeed, at paragraph 5 of Daniel Fori's petition, he says boldly, and I quote, that I am not required to produce any evidence to support any of the allegations I have made in this petition. And that is a basis. In fact, we saw that, but for the request by the CJ for copies of this petition to even assist the court in determining these mere allegations, bare assertions that were made by Daniel Fori in his petition, do we say suffices for establishing a prima facie case? I do not agree so. Again, in the same petition, he alludes to certain things that are including the exercise of some administrative functions without proof. And so something might fear, and that should be the fear of every Ghanaian, that somebody puts pen to paper, makes bare assertions, mere allegations against you, and that suffices as a basis for prima facie case. I believe we are lowering the threshold for the exercise of that constitutional process to remove no mere person, but the head of another arm of government, which is the judiciary. Similar arguments can be made with respect to the Akogo Ayamda case. Again, and he is the only one that attaches a newspaper item to his petition. And go and check that newspaper reportage of Law Platform at that time. He said it is only Tokonu who calls for his arrest. Again, sitting as a panel. And in that same exhibit, which he attached to his petition, you will find that the newspaper reported that even Justice Kwama made interventions to him and said that you cannot be this discourteous to the court. You cannot be this violent to the court. In other words, your act, as it is now, is being in contempt of the court. And we do not see any of the judges signing to say that they do not agree with what happened on that day. And so, something, I'm saying that I'm not being dismissive. If you have a grievance, if you have any dissatisfaction with any act of any judge, more so the Chief Justice, I'm not saying that we are gagging from expressing that dissatisfaction, but I'm saying that our very Constitution and the laws we have given to ourselves provide specific avenues for addressing these grievances and dissatisfaction. If you are saying that the processes are not sufficient, that is a different matter. Okay. And again, let me emphasize before I conclude on this that please let's not get the discussion wrong. The discussion for me has never been about personality. And that's why when I mentioned the teacher, when I go back and say at the Chief Justice, the discussion has never been about person. The discussion has always been about the office, has always been about the institution called the judiciary, an arm of government, which is no mean part of the democratic dispensation, part of our democratic dispensation.
Okay.
Thank you.
So a couple of questions for you, especially because you take leave of us midway or very quickly.